Okay, so let's keep going. So now let's talk
Yes.
about responding. You receive a request to admit.
Right.
Now, um, there was a famous case from 2020, and I found it. And I'm just going to take off where the court says the following, and I'm making it bigger because this is the reality of requests to admit. Requests to admit can be an effective tool to narrow the factual issues in dispute and focus the parties. When used properly, the request to admit assists the parties in furthering the primary objective of the rules, which is to deal with cases justly, including ensuring that the procedure is fair to all the parties, saving expense and time, dealing with the case in a way that's appropriate to its importance and complexity, and giving appropriate court resources to a case while taking into account the need to give resources to other cases. Used improperly, for example, to demand responses to assertions that are argumentative, not probative. Probative is a fancy word for doesn't impact the actual case. Okay, it's relevant, but it's not impactful. It's based on opinion or privilege. Okay, so those we're going to talk about that. Or not agreeing to reasonable requests for extensions of time in response to a voluminous material. Requests to admit may be used to harass and abuse the process of the courts, okay, which should not be tolerated.
Wow.
Okay, that's pretty strong wording about harass and abuse.
Wow. Yes.
And I want you to know from my experience, that's exactly what people use it for. Okay, I have seen some very good requests to admit, which really, you're like, oh, wow, they're really putting it to my client, right? If they say admit, that part of the case is over, right? Like, wow, they're really narrowing the issues by getting people to agree or deny to facts. That it's good.
Good.
And then I have also seen 600 numbered requests to admit, which are clearly meant to harass. Right? And the question is, what are you supposed to do about it? And the technical answer is, you're supposed to bring a motion and let the court decide.
Oh, wow.
Okay. And that's really the proactive way of dealing with it. Let me show. Now we're going to talk about responding to it, and I can show you how to passive aggressively respond to such harassment. Okay. So let's look at the request to the form 22A. Here's the 22A.
Okay.
And this is my response to your request to admit, dated whatever, so that there was a date on the other form.
Right.
That was served on me on this date. That's to peg it to the 20-day issue. And it says, I admit to that the following facts are true. And then you just number them. 1, 17, 84, right? I admit to the following documents are genuine. Okay. And then you say, I deny that the following facts are true. Okay, so 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, right? You could just keep that numbering up. And the next one is, I deny the following documents are genuine. And then it says, I refuse to admit the following facts for the following reasons. Okay, so remember what I said, that denial, you don't need a reason. You could just write the number. This list over here, sorry, this line number 3 is usually a very long paragraph of numbers, right? Where you're just you're denying most of the stuff unless it's accurate, and many times it's because they're poorly formulated. They're compound, right? They're compound, or they're argumentative, or they're legal, right? And so most of your requests to admit are going to be denials. And the refusals is interesting because it asks you for a reason why you're refusing to even answer. So I find that interesting. And presumably, if you refuse to give an answer, the other party can bring a motion to determine whether your refusal is good enough, right? Like, and if your refusal is not good enough, then you do have to admit or deny.
Oh, wow.
Okay, and what happens? And then after that whole motion, you say, okay, deny. And so the question is, what's the implication of denying? So we'll get to that at the end. Okay. But this is what the form looks like. There's nothing. If you refuse to admit about the documents being genuine, that has its own list also. Okay, about refusal. Okay, so let's go through it now. So again, your response is really simple. It's either admit to a particular fact or deny. No explanation, easy. You're just listing numbers. Okay. If you're going to refuse, you have to give a reason. So now I'm going to help you generate some reasons why you would refuse. Good. Number one, it's irrelevant.
Mhm.
It's irrelevant to the case. I'm refusing to answer your question about whether I cheated on you because it's irrelevant in law. Okay, that's an important one, right? Because relevancy is a very low threshold, right? But it is a threshold of are you talking about issues that are in the realm of what's needed to determine the case, the issues in the case. Okay. You can deny something that is uncertain or ambiguous, or you can refuse. You can say, and again, I to come up with different examples, it can be fun, but it can also, many people may not relate to it. But if you say something to the effect of, the wife was the primary caregiver during the marriage. Okay, now everybody says that, right? We all know that. But what does the word primary mean? What did that actually mean? Is that a fact? Okay, I would tell you that is an uncertain, ambiguous thing that statement that you can start arguing. What does that mean, primary caregiver? Like, what does that actually mean? So that would be under number two as an example. Number three, I've used a bunch of times where people ask facts that my client, why would they know? Okay, so for example, when there is a grandparent, like a party's parent who is involved and they have their own business and somehow the child is getting money, right? And so there's questions about the parent's business. And your client's like, how am I supposed to know that? That's not my business. I get money from my parents, okay, but what goes on over there is not in my direct knowledge, so I can't confirm or deny. Privilege is also a very common one. I mean, it's common for people who, if the person asking these facts, posing the facts, doesn't realize that they're going over a line, that certain items certain information cannot be given, even if you know the answer, that you can admit or deny it, because it's legally privileged. Either there's different forms of privilege. There is solicitor-client privilege. There is settlement privilege. There's a bunch. So this is almost like a legal bubble where you say, I could answer this, but I am refusing to answer it because it's privileged. It's within the legal bubble of privilege. Okay, unduly burdensome. You can ask a simple fact, right? So watch this. During the course of, this is the fact, during the course of the marriage, the Netflix charge was on, Visa XYZ. At least once. Here we go. I'm making it very simple. During the course of the entire marriage, the Netflix would have been charged at least once on Visa 123. Okay? Now, that is a very simple statement, but to confirm or deny that would require years and years of reviewing Visa statements, right?
Oh, yeah.
So that would be an unduly burdensome fact to commit to, and you can refuse it, kind of thing.
Yeah, that's a good
You get
example.
that?
Yeah.
Okay. Okay, these ones are also, the truth of the matter is annoyance and embarrassment, frankly, I would say is number one, irrelevant. Okay, but sometimes people want to get zingers in there,
Yeah.
right?
Wow.
About the other person's conduct or something to them to make them look bad.
Yeah.
I'll give you um, where there is a situation where somebody has, let's say, a substance abuse,
Mm-hmm.
okay? And let's say it has no bearing on the case. There's no like parenting issue related to it, and there's no money issue related to the spending of money. Okay, because there could be some relevance, but let's say there isn't. So for somebody to say, the person went to AA meetings, that's the fact. During the marriage, the respondent went to AA meetings.
Right.
Well, that's not relevant, and it's like, why are you bringing that up? I mean, there's nothing wrong with it either, right? But the point is, I'm just trying to show like how people try to put in zingers that have nothing to do with the case, but are just to kind of make the other party, oh, come to terms with that. Yeah, you admit that you have a drinking problem.
Yes.
Okay. I mean, the last one is also very tricky. Um, I would say, by the way, this is not a definitive list. I'm sure I can come up with another 10, but these are the top ones.
Okay.
Okay, so the applicant has a constructive trust interest in the respondent's house. That's the fact, right? Okay, and I say constructive trust interest, I'm saying that very specifically.
Right.
Okay, because constructive trust is a type of award. Okay, so it's a legal conclusion.
Right.
Okay, so so um
Yeah.
so you can't win a case from a request to admit. That's not what a request to admit is for. It's not about the issues. Remember, I said at the beginning, you could agree that you agree on certain issues, right? But that's not what a request to admit. Request is for facts. Okay, so the applicant paid in May 2021, the applicant made a payment of $30,000 toward renovations of the respondent's house. That's a fact.
Right.
Okay, even that I would say is a little bit broad. I would be more specific. The $30,000 went toward this contractor, like make it very specific, right?
Right.
And so but to say, oh, like this is the outcome of the case, admit or deny, that even if the person doesn't respond to the request to admit, so they're deemed to admit, a court's not going to say, oh, you win the case because the other side didn't respond to it. Okay, so don't do that, and that's a good reason to refuse a statement that's purportedly supposed to be a fact, which is really a legal conclusion. Okay. Oh,
Oh, there's more.
there is one more. Yeah, I'm telling you, there's so much more.
Yeah.
Sometimes people want people to admit to facts, and it's too early in the case. It's almost like it's not in your direct knowledge, but really, you're still looking into the facts. Okay, because there is we don't use the word discovery, we use the word
Right.
disclosure, but in civil litigation, the concept of discovery is the entire bubble or the entire timeline of when you're supposed to be providing information to the other side or exchanging, right? And that includes, in our case, 13.1, 13A. It includes questioning. It includes affidavit of documents. So there's different tools for gathering information, and for somebody to admit to a fact when you don't even know the facts yet, because you haven't gone through the whole discovery. And that's why I was saying it's not likely that you're going to get a request to admit at the beginning of a court case. It usually is after the discovery phase, closer to trial. And let's just conclude here
What?
with withdrawing.